Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. On Monday, a new bill was introduced in the Lok Sabha. The bill is called the Criminal Procedure Identification Bill 2022, and it gives the police some unprecedented powers. It allows them to collect, store, and analyze physical and biological samples in a way that has never been done before. The bill has been called draconian and has raised several concerns about privacy and its possible misuse. In this episode, we take a look at what the bill allows the police to do, the concerns it raises for ordinary citizens, and why it appears to violate fundamental rights. To talk about this, we first speak to Deeptiman Tiwary, who reports on government agencies for the newspaper. Deeptiman, to start off, if the bill is passed, what all would it allow the police to do?
Look, until now, what we had under the Prisoners Identification Act was only footprint and fingerprints could be taken. And it's a 1920 Act, so modern technology that is available today was not available at that time. So the legislation only covered what the technology allowed at that time. And now we have multiple means of collecting evidence, and so many technological advancements in forensics have been made over the years. So the need for a new law to allow, as it is done in the US and several other developed countries. So the new law which is being proposed, if it passes Parliament, which it definitely will allow not just fingerprints, but palm prints. Footprints are already there. Iris scans. Most importantly, biological samples, which means that your blood samples or your saliva, which can allow the police to take DNA samples and preserve it for future reference. Then photographs, although photographs were mentioned in the last law also, but that was through a magistrate, that you petition a magistrate and then magistrate allows. Now a policeman can take photographs. Then handwriting, signatures. So all these samples can now be taken by the police, which falls in the behavioral category, to preserve for future reference. And they will be stored on probably a cloud, which the National Informatics Center is already developing. So these are the few changes.
Okay, and who all could the police take these measurements and samples from?
Just about anyone who is accused of any crime or even detained under a preventive law. You know, there are many such preventive laws, such as the National Security Act in UP, which is used very frequently in UP, or the PSA, Public Safety Act in Jammu and Kashmir. And there are many such preventive detention acts. Even under CRPC, there are sections for preventive detention. So in all of those, and arrests, and if you're convicted, in all these cases, your samples can be taken. Now, what is different from the previous act, which is the Prisoners Identification Act, is that earlier there was a condition that any person has to be accused of a crime or convicted of a crime which carries punishment of at least 1 year of imprisonment or more. Now that also has been removed. So even if you're convicted for 1 day, you'll have to give these samples. Even if you're accused of a crime which carries a punishment of, say, 3 months, for example, some kind of motor vehicle violation, which also carries a punishment of 3 months, if you don't pay the fine, or say minor violations of financial kind, which carry 6 months of imprisonment, or traveling without ticket in a train. If you don't pay the fine, it carries an imprisonment of 6 months or 1 month or whatever. So in all those cases, you will have to, and there is no option. The law is very clear that if you do not allow it, if you do not agree to give these samples, everything else that we have just mentioned, then the police will be within their right to use any means possible to get it out of you, which basically saying that the police can forcibly take it from you if you do not give your consent.
And does the bill speak of any exceptions, people who can refuse to give any of these samples?
Okay, there is an exception provided in one of the measurements, which is the biological samples, which means if the police wants to take your DNA sample, if you're a convict, then you have no choice. You have to give it. Okay. But if you're only under trial, that is, you've been accused of a crime, then your consent has to be taken for taking your DNA sample, either your blood sample or which is called a biological sample in the law. However, if you are accused of a crime which involves child sexual abuse or sexual abuse of women or an offense that carries a punishment of minimum of 7 years, then you don't have your choice. Then you have to mandatorily, if the police demands, then you have to mandatorily give biological samples as well. Consent is required only if you're not accused of these heinous crimes.
And do we know who all would be able to collect these samples?
The earlier law mentioned that it has to be the station in charge or minimum any investigating officer or at least a sub-inspector, not below that. But now all these people can take, as well as a head constable, which is, you could say, 2 notches below a sub-inspector or 1 notch below a sub-inspector, head constable. And sub-inspectors generally come through a direct entry, whereas head constables rise through the ranks from, a sipahi to constable to head constable and cannot go beyond. Maximum they become assistant sub-inspectors. So yes, it has been brought 2 notches below as to who can take the sample. And its scope has been increased because the number of measurements have increased and the number of offenses, in the sense that because the limit of 1 year of imprisonment, that has been removed. So the scope of offenses has also increased massively. So you could be forced to give your samples for just about minor of offenses that you may have committed out of sheer oversight or not knowing the law. I mean, for example, I was once traveling through Himachal and I was fined for traveling with those sunshades on my windows because my child was sleeping in the rear seat. Now, when I drive from Delhi to Himachal, I don't read all traffic rules. Okay, and the traffic inspector told me that, boss, in Himachal, it is not allowed to use these shades. I was like, I didn't know. The reply was that ignorance of the law is no excuse. So what do? I mean, this is a genuine mistake. I had to pay the fine. Now for that, it's an offense, which if I don't pay a fine, can carry some sort of imprisonment. So you take me to the station house. You take my sample.
Right. So just based on this, they could take your retina scan or fingerprints and other things.
Everything. Except my blood and my hair and my saliva. Everything else they can take. See, of course, it remains to be seen as to rules will be framed, whether certain checks and balances can be introduced in the rules. And these rules will be framed because police is a state subject. So all state governments will frame their own rules. Okay, apart from the center framing its rules. So it remains to be seen what kind of checks and balances can be introduced in these rules, because this has the potential of misuse. Of course, the government will argue that the data will be fully protected and everything, but it can cause a lot of harassment to people.
Okay, so the bill has been met with a lot of opposition. Could you talk about the kind of things that have been said about it?
Of course, one of the biggest arguments of the opposition is that this is a violation of fundamental rights. You cannot force people to give fingerprints are okay, but biological samples and everything else that you're asking for, most minor of offenses, is totally uncalled for. And the opposition says that this is prone to misuse and that the government is acting like a big brother, watching over everyone, and the data could be misused tomorrow. And it is a violation of privacy, individual freedom, fundamental rights. And people have also said that this is going to be challenged in the Supreme Court and will not stand the scrutiny of the court. So these are some of the concerns that the opposition has expressed on this entire thing.
Also, Deeptiman, the government has been digitizing fingerprints for some time now. But when we talk about facial recognition, retina scan and DNA samples, when did the push for these things start?
Look, digitization of fingerprints started way back in the UPA era itself. And it was something to be done as well, because technology has advanced so much and preserving printed fingerprints can be very difficult over a period of decades and all. And they wear off and then you can't match even when you have it because it's in such a bad condition. So that was a necessary thing. And it started with CCTNS, which is the Crime and Criminal Network Tracking System, which was again started by the UPA in the aftermath of 26/11 attacks. CCTNS is basically a system which connects all police stations in the country into one central database. So every offense which is committed anywhere is directly fed into that database, and anyone connected to that system can access that data in real time. So if at 12 p.m. an FIR is registered in, say, a police station in Kerala, a policeman sitting in Bihar can access it and see that, okay, fine. So what this basically does is that if criminal is fleeting from one state to another, it helps to identify. Suppose that criminal is arrested in some other offense. You check it in the CCTNS and you say that, okay, he may have been caught for theft, but he is actually accused of terrorism in Kerala.
Yeah, so without this, the Bihar police is basically in the dark about the previous records of the person.
His antecedents. And so all these things that the government started doing, which it said that, okay, modern technology takes iris scans, takes blood samples and DNA, and there is facial recognition software, all this can greatly aid police investigation. And so they started on a project which is part of the CCTNS phase 2, where all these systems are supposed to be integrated into CCTNS, where all this data of iris scans and fingerprints and, for example, even fingerprints at the moment are in silos. All state governments have their own fingerprint departments where they have their own state database. Then there is a central database. But there is no one single database which is a repository of all these fingerprints. So that work is also on, where with the CCTNS, when it is integrated, anyone can access the fingerprints of any state. Similarly, when iris scans start being collected, and this law is going to precisely allow that, or blood samples start being taken, all this can be integrated into CCTNS and to give real-time access to all police personnel, central agencies, police stations across the country. Let's remember that, where this is coming from. In 2009, notorious Indian Mujahideen operative Yasin Bhatkar was arrested in Kolkata for a minor offense. The Kolkata police had no idea who he is.
Oh, so they caught one of the most wanted terrorists in the country, but they had no clue about it?
They didn't know. Okay, he was obviously on an assumed identity and he was caught. They had no idea of who he was. There was no fingerprint matching or anything or whatever. And he was let off because it was a minor offense. It was only later when he was caught that it was realized that, okay, he was caught in 2009 also. And by then, Indian Mujahideen had already carried out a series of blasts across the country, killing hundreds of people. So these are the things which are very, very essential for tracking criminals. And these are already in use in developed countries such as the United States or other European countries where it is used for criminal tracking. We can also take the example of 2013 Bodh Gaya blasts, where when the NIA went to investigate, they found an abandoned Buddhist robe near the blast site. And they picked up DNA samples out of it. Later, when Indian Mujahideen operative Haider Ali, he was arrested for the crime, his DNA sample was matched with those found on the robe. And that's how he got convicted, because this was scientific evidence. So yes, these are all very, very necessary steps which need to be taken in the context of modern technologies aiding investigations. But at the same time, any law which is brought needs to take care of individual privacy, needs to take care of fundamental rights of citizens, and put proper checks and balances within to ensure that it is not misused and people are not harassed.
Now, like Deeptiman mentioned, there have been many in the opposition that have raised concerns about this bill. Here are a few things that were said in the Lok Sabha on Monday.
This August Assembly must very seriously deliberate that whether it is in the legislative competence of the Treasury to sponsor legislation which squarely hits the fundamental rights guaranteed to the citizens of India under Part 3 of the Constitution, and whether it is within the legislative competence of this August House to consider such illegal legislation. That is my objection to the bill.
Sir, if I am arrested, you kindly go through the bill. If I am arrested in picketing the collectorate for the civil right protection or for any genuine demand, if I am arrested and FIR has been lodged against me, suppose if DNA test can be taken from me. What is this? This is the basic human right of a particular individual. It is being taken away. What is the reason? What is the logic, intention of the bill? Kindly explain this bill.
This law, which allows for narco analysis, which allows for taking biological specimen, taking the photograph of the iris. This violates basic human rights and is against the principle of the Constitution.
In the episode so far, we have discussed what the bill talks about and how it could affect ordinary citizens. In the next half, we talk about the concerns the bill raises from the legal point of view and why people are saying that the law could be challenged in the Supreme Court. And for this, joining us is Indian Express's Apurva Vishwanath, who writes on law for the paper. Apurva, could you break down the various concerns this bill raises, especially from the legal point of view?
So the issues with the bill that the opposition has raised involve how it balances fundamental rights, especially the right against self-incrimination and the right to privacy, which are guaranteed by the Constitution. And additionally, the bill has a lot of terms which are vague or too broad, are just not defined adequately. So these are the key concerns in the text of the bill that has been introduced in the Lok Sabha.
Okay, so why don't we tackle this one by one, starting with the right against self-incrimination?
So first, the right against self-incrimination, which is in Article 20, Clause 3 of the Constitution, says that no person can be compelled to give evidence against himself. So this bill, which basically collects a lot of personal and biological data from those accused of crimes, it will have to be seen to what extent this affects the right against self-incrimination.
Also, when we talk about the right against self-incrimination, this fundamental right, in this case, the idea that my DNA, my retina scan that was taken from me could lead to me being incriminated, is that the reason it's violating this fundamental right?
Like in a criminal trial in India, the law states that it is a prosecution who has to prove beyond reasonable doubt that a person committed the offense in order to secure a conviction. So it is not upon the accused to volunteer information. So in cases where the police want certain information, right now what they do is they go to the magistrate, ask for an order which compels the accused to cooperate. Otherwise, there is the right of self-incrimination, which allows you to say that I do not want to contribute or give evidence against myself. The law cannot force me to do that. Like in popular culture, we are probably much more familiar with the fifth, pleading the fifth in the American Constitution. So that is a right to remain silent, a right to not incriminate yourself by saying something against you. So collection of a DNA sample, collection of blood samples, these are all things that could fall under that realm. To what extent and at what stage can you refuse is all for the court to decide. Because would that right kick in when you're a suspect in a case or when you're charge sheeted? Because when you're charge sheeted, that means there is a prima facie case against you. So your right to self-incrimination might be of a lesser degree compared to when you are a suspect and there are multiple suspects in that particular case. So these are questions of degrees and something that the bill does not address at this stage.
Okay, so the right to self-incrimination is one aspect. But the other concern being raised about the bill is regarding the right to privacy, considering it allows the police to take measurements and biological samples, in many instances even by force. Now we know that violating someone's right to privacy is illegal, but are we allowed to have laws that violate someone's privacy but for the greater good of the public and the state?
So the Constitution states that any law which is violative of fundamental rights cannot be allowed. But on the other hand, fundamental rights do have certain what we term as reasonable restrictions that are mentioned in the Constitution. So for the state to make laws that are violative of fundamental rights to that limited extent, which is certain standards laid down in the reasonable restrictions, the state will have to show that they qualify as reasonable restrictions. And if you look at the Supreme Court's Puttaswamy judgment, in which it did say that the right to privacy is a fundamental right, it puts the onus on the state to show that they had a legitimate interest in bringing in a law that does encroach on fundamental rights. So what is that legitimate interest, and whether something qualifies as a legitimate interest or not is something that the courts could address at a later stage. For example, in the Aadhaar case, the courts agreed with the government stand that distribution of welfare schemes, like ensuring equitable distribution of public goods through welfare schemes, is a legitimate state interest. And to achieve that, you could violate fundamental rights to a certain extent. So in this case, again, law and order, national security, these have been considered legitimate state interests. But the issue of proportionality, because this law is essentially about databasing, it is about storing this personal sensitive information for a period of 75 years by the police. So this aspect of databasing will have to pass the test of proportionality, which perhaps court will have to look into at a later date.
So the other issue you had mentioned earlier was that there is a lot of lack of clarity about this bill. There are things that have not been adequately defined. So talk about that a bit.
So the bill replaces the 1920 Identification of Prisoners Act. So the 1920 Act was limited in its scope and it pertained pretty much to convicts in a jail and to some other offenders. And it involved collection of data of very limited aspects, which is your finger impressions, foot impressions, and photographs. Perhaps these were the ones that were used most commonly in 1920. But the law now expands in its scope and reach. First, it says that the measurements which can be collected are now very wide ranging. This will include palm prints and photographs, iris and retina scan, and also biological samples and their analysis. But if you look at the text of the bill, it does not define what biological samples and their analysis would mean. You can broadly expect this to mean voice samples, collection of blood and hair, DNA samples. For all of these, currently you require an order from a magistrate to collect, say, for example, a DNA sample from an accused. But this law allows the police to do so without the order of a magistrate. So that is one crucial change and something that will have to be looked into. And because the phrase biological sample is not described, it could involve a lot of things which are bodily invasive. So that is where the balancing between the right to privacy and the state's interests will have to be looked into. And second, perhaps the most vaguely described part is Section 3 of the bill, which talks about who is the subject of this law. So this again casts a very wide net on those whose data can be collected.
And could you give an example of how this is being described in the bill?
So if you look at the text of the bill, it says that those convicted of an offense will be subject to this law. And then it says those ordered to give security for good behavior. This is somebody who gives a surety bond, as we call it, to a magistrate. And the third is, of course, those who are detained under preventive detention laws or those who are arrested, so under preventive detention law. It seems pretty straightforward, but when you look at the proviso, which is the exception to the law in this particular section, it says that provided that any person arrested for an offense committed under any law for the time being in force may not be obliged to allow taking of his biological samples under the provisions of this act. So essentially, what the exception to the law states is that the police can, in fact, collect the data from anybody, but only a certain category of people, like I said earlier, which involves convicts, those under preventive detention law, can be compelled.
Compelled meaning the police can force them to give these samples.
So compelled means only those cannot refuse to give their personal information. So this negative drafting of the law actually casts a very wide net. It says everybody is covered under this law, but only some can say, I will not give my data. So it puts the onus on the citizen who is in the police station to know whether he is required by law to share his biological data or not. Especially because even someone who's charged with a petty offense, like we saw many such cases during the pandemic, might walk into a police station and might not be aware that he is exempt under the law. So it really depends how the police informs this person and whether there is an informed consent involved in sharing of that data. So these are other issues when you come to data protection and how information is collected from individuals.
Okay, so the bill doesn't define what biological samples are, and it is also vague about who all could be subjected to giving these samples. What else is the bill not clear about?
So the bill leaves one more incongruity, which is for juveniles between the age 16 to 18. So as we know, those under the age group of 16 to 18 can be charged under the IPC and not under the juvenile justice law for committing serious offenses. So those will be tried under the IPC and they will be in a police station. Otherwise, the juvenile offender is not in a police station. So the law doesn't specifically state what happens to these between the age of 16 and 18 who are still minors and can't give an informed consent, but they can still be subject to this act. So this is something that the law leaves out here. And I think lastly, it is the question around data protection. There is a data protection bill that is pending, that has been in the pipeline for a long time now. And in the absence of such a data protection framework, there are a lot of questions on an individual's control over the data that, say, the NCRB has. If there was a data protection framework, there would be an independent authority who would sort of audit the database and give me a right to ensure that the data concerning me is deleted, or I would actually know that the data is in fact deleted. But without that, the NCRB has the powers to store, preserve, and destroy the record of measurements. But there is no way that the data principal has a say in the process entirely.
You were listening to Three Things by The Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.